My name is George Levy. I'm a patent agent, which means that I'm licensed by the Patent Office to practice patent law. This is my specialty. Before becoming a patent agent, I was working as an engineer on cruise missiles, military radars, communication systems, and navigation systems. Before I begin my presentation, I'd like to present you with a little test. Are you ready? Are you ready for a test? Okay. You're driving in your car. It's a small car, and it's a wild and stormy night. It's raining, it's awful. And you see at a bus stop 3 people. They're waiting for the bus. The first person is an old lady. She's sick. She's tired. She needs to go to the hospital quickly or she's going to die. The second person is, by chance, your best friend from college. He's a math genius. He helped you with statistics in a statistics exam. He was sitting right next to you. I'm not going to get into how he did it, but he did it. He helped you, and you passed your exam. So you owe him big time, and you'd like to give him a lift. Here he is. And the third person is the lover of your life. It's a long story, a very emotional story. Here she is. But this is your last chance. If you don't give her a lift, you will never see her again. You have a small car. There's room for only one single passenger. Which one will you pick? Will you save the old lady's life? Will you pick up your best friend? Or will you give a ride to your lover? Who says the best lady, the old lady? Who says the best friend? Who says the lover? Sorry, you're all wrong. All right, none of the above. None of the above. You give the keys to the car to your best friend, and you ask him very nicely, please drive the old lady to the hospital, okay? And now you're alone with the girl waiting for the bus. And you solve the problem, all the problems. What does this story have to do with intellectual property? Nothing? Well, yeah, you've got to think outside the box. The answer was none of the above. I gave you 3 choices. The 3 choices was help the old lady, give a lift to your friend, and give a lift to your girlfriend. And the answer was outside of that. You had to have the courage to challenge me. There were just a couple of guys who challenged me, but most of you did not step outside that box. In the real world, solutions of problems are none of the above. Okay, you've got to step out of the box. What you've been taught is either incomplete or wrong. You've got to ask why. But when you ask a question, you better know what you're talking about. If you're going to design a perpetual motion machine, you better know the laws of thermodynamics. Inventing requires a lot of work. As Edison said, 1% inspiration, 99% perspiration. I like what the old Greek philosopher Heraclitus said. He said, there's no permanence but change. I'd like to change that to, there's no truth but doubt. Okay, so ask why. Keep an inquiring mind. What is intellectual property? There are different kinds. Things like books, any kind of writing, movies, music, lyrics can be protected with copyright. Things like business names, trademarks, business logos can be protected with trademarks and trade names laws. If you have an artistic design which is applied to a useful object, for example, a beautiful car or a cell phone with particular icons artistically designed, or a nice bottle, these objects are subject to design patents. If you have a biological object which can reproduce itself and maintain its genetic integrity, so that requires asexual reproduction. Okay, if you have such a biological organism, and usually some plants are like that, you can protect them with plant patents. Machines, apparatuses, chemical compositions, processes, methods, recipes can all be protected with utility patents. In the old days, people had trade secrets. Professions used to guard their secrets very jealously. So the government came along and made a deal. They said, we'll exchange, we'll offer the inventors the right to protect their invention, to have exclusive rights to their invention, in exchange for them divulging the invention to the public. Because in the old days, ideas were kept secret. So the patent law, the purpose of the patent law was to stimulate the movement of ideas and to stimulate progress. So this is intellectual property. Now let me talk about, I'll be talking to you today about how to go from an idea to a finished product. Business plan, search, defining your invention, then describing your invention, claims, filing your invention, provisionals, why get a patent, and licensing. Each one of those steps is a filter, is a check, okay? You do your preliminary business plan. If you're not going to make money, you stop right there. And by the way, you do this because you want to avoid having to go to a large invention promotion company, put down $10,000 or $15,000 up front before they can even begin to give you a boilerplate search result, which is not worth much. So this is a low-risk approach. Low-risk, step-by-step approach you do yourself. So you start with the preliminary business plan. If you're not going to make money, you stop. Then you do the search. If your invention exists, you stop. If it's not quite the same, you can revise your invention and try again. Then you file your provisional. That gives you a year to refine your invention and try again. You file your prototype, you build your prototype. If it doesn't work, you stop. So each one of those things is a test for you to stop or reevaluate. First, let's start with the business plan, and Adrian has a great website. You can go there. But the one I like the most is the SWOT analysis: strength, weaknesses, opportunities, and threats. And you can apply the SWOT analysis to any aspect of your business: the technical issues, manufacturing, marketing, financing. If you want a great example of a SWOT analysis, it's given in the HBO TV series Silicon Valley. I don't know if you're familiar with that one. It's great. So it's season 2, episode 6. Remember that. Silicon Valley, season 2, episode 6. And they apply the SWOT analysis to people. It's hilarious. You have no idea how funny it is. Then you do the search. Now, the search has 2 reasons. The first one is to make sure your invention does not already exist. If it exists, you don't want to have to pay royalties to the patent owner. The second reason for the search is to be able to write good claims. If you don't know where the neighbors are, you don't know where to put the stakes in the ground. If you put them out too far away, you'll be infringing. If you put them too close, you'll be depriving yourself of coverage. So you're looking for Goldilocks claims. And this search will help you define the Goldilocks claims. Keep a record of the search. That search will eventually be sent to the patent office. How do you search? There are great tools on the web for searching. You have Google, which is wonderful. At the US Patent Office web page, you have a great search engine. Then you can go to the European Patent Office, they also have a great search engine. The Japanese Patent Office also. And you've got WIPO, the World Intellectual Property Organization, which also has a great search engine. So if you do a search on Google, the US, Japan, and Europe, you'll find. But the thing is this: no matter how much effort you put in the search, it won't be perfect. No one can do a perfect search. And the reason is, anything that has been published in the history of civilization, in any language, in any country, can be used against your invention. To do a search like this would cost you millions of dollars, but you've got to keep things in perspective, spend in proportion to your invention. So something that between $500 and $1,000 search possibly will do the trick, but no search is perfect. After you do the search, you ask a professional to repeat it. It's money well spent. Believe me, I've had well-educated people come to me claiming to have done a search, and I repeated the search and I found lots of things. So it's money well spent. You've done your search. Now, you've got to define what your invention is. It's not your idea. Your invention is not the idea. The invention is the innovation in your idea. It's the difference between your idea and the prior art. It's a difference. And that difference has to be described in a structural fashion. And the difference has to have utility and should be non-obvious. These are complicated concepts. Obviousness is a complicated concept, but for example, a change in color, that's obvious. That's not going to do the trick, and that's not going to change utility very much unless you're a matador or something like this. A change in material, plastic to wood, for example, in general, is not going to do anything. So that's not. The structural difference has to be meaningful. It has to produce utility. I like to describe the structural difference in terms of a Venn diagram. So let's say you start with your idea, that yellow circle, okay? And you apply the search. So now, what's in here is not patentable. This may be patentable. After having applying the search, you want to apply the legal aspect, the law, the legal constraints, obviousness. So now, the green stuff is patentable, okay? This is obvious, that yellow stuff is obvious. That's under your original idea, but a good patent attorney or agent will extend the scope of your invention beyond your original idea to make it broader. So a good claim will actually extend your invention, the coverage of your invention. So you've defined your invention. Now you know what it is. You know exactly what the innovations are. The next step is to describe it. And the description has to be structural. Okay? You don't describe it in terms of what it does. I mean, that's interesting. Sure, you have to put that in. You've got to put that in. But the important thing is the structural description, the components, how they fit together. Okay? So you have your structural description and the interrelation between the different modules and components. If the patent is a method patent or a process patent, then you have to describe the steps, what that process is made of in terms of steps. And you always focus on innovations. That's the important part in your patent application. The innovation, this is what's important. Marketing terms, the best in the West, and the must-have, who cares? The patent office doesn't care about that. I mean, you can put it in, but it's best to just leave it out. And commercial products are shiftable. They can change. For example, W40. Who knows what W40 is made of? If, for example, you say your chemical composition consists of a little bit of glycerin, a little bit of W40, well, everybody knows what glycerin is, but nobody for sure knows what W40 is because the manufacturer could change something. It could add something, subtract something. So all commercial, you don't use commercial product in defining the components of your invention. Okay? Velcro is a commercial term. Don't use the term Velcro, use hook and loop. Okay, hook and loop, that's not commercial. Velcro is commercial. Now, you've described your invention, now you have to claim it. And as I said, the claim is the legal definition of your invention. So the claims is a combination of your idea, of the search, and of all the legal requirements that the claim should have. It's a synthesis of all this. Claims are very difficult to write. This is one of the hardest things you can imagine, writing claims. Very tough. They should not be too wide, and they should not be too narrow. When do you file? So now you've got your invention ready to be filed. When should you file? In the old days, we had the first to conceive laws, where you could keep a logbook of your ideas or your progress. If the logbook was properly notarized or dated, then you could use that logbook as a proof of an invention date if somebody else files before you. Okay, so you say, oh, but I invented first. Not anymore. Now it's first to file. First to file. So if you go to someone and you talk about your invention, and that person publicizes your invention without giving you credit, he will lock you out. You will not be able to get your patent because it's published by somebody else. Best thing to do is try not to talk to about the invention too much until you file at least a provisional. So we have a race to the patent office. Some of us are slow, and some of us are fast, and some of us get their patent. Now let's talk about provisionals. Okay, so a provisional is a document which is filed with the patent office for the only purpose of getting a filing date. Okay, you get a filing date. The document is not examined. It's on the shelf for 1 year, after which it becomes irrelevant, maybe thrown away. And the non-provisional has to be filed within that year. And it refers back to the provisional to benefit from the early filing date of the provisional. Now, the provisional has to be well written. The claims are not necessary in the provisional. Claims are not necessary, but the claim language that you're going to use in non-provisional later has to be in the provisional. Otherwise, when the time comes to write your non-provisional, you won't have the support in the specification for your claims. So even though the claims are not necessary, it is important to put the claim language in the specification. This way you have the backing in the specification when you write your non-provisional. So when I write a provisional, I make sure that it's well written. So the advantage of a provisional is that, first of all, it establishes a filing date with the USPTO. If your invention is not fully baked, you have 1 year to refine your invention. And when you file your non-provisional, then you can roll into the non-provisional all the improvements that you've made. Of course, those improvements do not benefit from the early filing date. You cannot cheat. But at least what's been filed as a provisional is protected. Another advantage is that it extends the life of the patent beyond the 20 years because you benefit from almost a whole year worth of provisional time. Another important advantage of a provisional is that it gives a clear legal description of what the invention is for the purpose of cooperating with the company for developing your invention. See, companies are reluctant to sign NDAs with inventors. Why? Because usually they have a team of engineers in the back room working on their own product. If you come along with an NDA, with almost a blank idea, and you say, please sign this, they can be reluctant. If they sign it, they could jeopardize their whole research and development. So companies may be reluctant to sign NDAs, but with a provisional, there's no problem. It's already filed. And it's a clear black and white description of your invention. There's no wiggle room. With an NDA, there's wiggle room because you don't know what you're dealing with. So a provisional is a good way to start a business relationship with a company for development purposes. The disadvantage of a provisional is that, first of all, they are not patents because they are not examined. They extend the examination process by about a year, and The backlog with the US Patent Office could be 2 years, 3 years, 4 years, 5 years. So it extends all this by about a year. And the provisional is not a proof of ownership. It's not a title to ownership. It's a shield, it's not a sword. It protects you, but you cannot sue for infringement on the basis of a provisional. So, why get a patent? Well, you want to defend yourself against possible infringement. And if you want to sell a license, why get a patent? If you want if you want to sell a license, you have to show ownership, title, right? And title to invention is a granted patent. That's a title. I'm infringing a little bit on next month. Licensing, okay? You want to be in a good bargaining position for licensing. It's hard to be in a good bargaining position, okay? How do you do that? Well, as I said, the provisional is not a proof of ownership. Can you start a licensing or selling agreement on the basis of a provisional? If you say yes, then I can sell you the Brooklyn Bridge, right? Because I don't have license to the Brooklyn Bridge. So, yes. And I call that the flim-flam method. The flim-flam method is selling something you don't own, right? It works sometimes. Requires 2 ingredients. A very good salesman, and a very naive buyer. So with those 2 ingredients, the flim-flam method does work. And the method requires to say as little as possible, keep the buyer in the dark, keep it gray and ambiguous. That's how the flim-flam method works. It works sometimes. It does not work with experienced attorneys and buyers. Now here's a yellow brick road. It's a long road. You start with the idea and you follow the road. The further along you are that road, the stronger your bargaining position. Okay? At the beginning, you have almost nothing. An idea is almost nothing. And you follow the road, eventually you reach the provisional stage. This is where our friend is trying to sell his invention at the provisional stage, right? But you're not in a very good bargaining position. You don't really have a title yet. You build your prototype, you get your non-provisional. So okay, fine, you have it, you have your title, but you're still not strong enough. You've got to show that it's a business, that you make money. So you follow the road, and the further along you are, the stronger you get. So if you want a good licensing, a good position for licensing or selling, you've got to go as far as possible along that road until the kingdom of ours. You cannot do it all yourself. It's too big. You can do some of it, but eventually you're going to have to rely on professionals. And we're talking about intellectual property, engineering, drafting, web design, video presentation, and marketing, managing, funding, licensing, selling. We have in this room a lot of those experts. Leslie is an expert in licensing. Sydney does video presentation. And we've got Christina over there who does web design. And I'm sure we've got some drafting people, and David Weller and myself are intellectual property people. So you have to, eventually you have to rely on those people, because these skills are really difficult. Like I'm talking just intellectual property. Claim writing is very tough, okay? This is my last slide. But before I give back the podium to Adrian, I'd like to show you a little song and dance. A little song and dance that will describe to you how to describe your invention. It'll show you how to describe your invention, this song and dance. Are you ready?
Them bones, them bones, them dry bones, them bones, them bones, them dry bones, them bones, them bones, them dry bones, them noisy dry bones. Them bones, them bones, them dry bones, them bones, them bones, them dry bones, them bones, them bones, them dry bones, them noisy dry bones. Big bone connected to the ankle bone, the ankle bone connected to the leg bone connected to the knee bone, the knee bone connected to the thigh bone connected to the hip bone connected to the backbone connected to the neck bone connected to the head bone, them noisy dry bones. Them bones, them bones, them dry bones, them bones, them bones, them dry bones, them bones, them bones, them dry bones, them noisy dry bones. Finger bone connected to the hand bone connected to the arm bone connected to the shoulder bone connected to the backbone connected to the neck bone connected to the head bone, them noisy dry bones. Them bones, them bones, them dry bones, them bones, them bones, them dry bones, them bones, them bones, them dry bones, them noisy dry bones, them bones, them dry bones, them bones.
All right.
Ladies and gentlemen, George Levy, hold on.